Hello, good morning, good afternoon, good evening. I hope you're all doing well. As promised, this is part 2 of the state of Indiana's response to Richard Allen's appeal. This, of course, is referring to the Delphi case. As promised, I know it's a bad time for most of you, but we're here, and the sooner we get started, the sooner we finish. I didn't get very far through yesterday, but I think we can get famous last words, I think we can get through this quicker because there will be some repetition. So it's not like I've got to, have an angry discussion about certain points. Anything that I talked about yesterday, I'll try and skip that angry discussion. But I have gone live about 5 minutes earlier than I advertised. Again, sooner we start, sooner we finish. Hello, Mama Shark. We got Teresa, we got Fig, we got Sai, and some numbers. Is he maybe? It's not Sai. Confuses me when there's lots of numbers in someone's name. Doesn't take much to confuse me, though. Hello, the Quiet Observer. And we've got Resi Cup. We've got Deb, we've got Gloria, we've got Cindy from New Zealand. Good time for those down under. Good time for those in Europe. Good time for those in Africa. Not so good time for those in America and Canada, who comprise 70% of my audience. But you can always watch it on the replay, can't you? Anyway, without further ado, we're going to get going. So we're starting here on page 28. This is the argument. So I'm going to skip through things like legal citations, just to make it a little bit quicker. And this is the argument that the state is putting forward as to why Richard Allen's arguments in his appeal, so all the points that he made in his appeal, are to be ignored, are not relevant. So, number 1, the court properly admitted evidence found pursuant to a valid warrant search of Allen's house. So this is the search warrant where they found a blue Carhartt jacket, where they found a Winchester round, where they found the Sig Sauer P226 firearm, etc. So that took place in October of 2022, shortly before he was arrested. The search warrant for Allen's house validly established probable cause. Therefore, the court properly admitted evidence found in that search: the gun, a .40 caliber cartridge found in the bedroom, a blue Carhartt jacket, and knives. Because this appeal follows a completed trial, the issue is whether the evidence was properly admitted at trial, and the ruling is reviewed for an abuse of discretion. But to the extent admissibility turns on the constitutionality of a search, uncovering the evidence, the question is reviewed de novo. There is a footnote here. The vast majority of Allen's first Franks motion that was released in September of 2023, and all his subsequent Franks motions, there were 4, I think. Was there 5? I can't remember now. I think there were 4. Are addressed in these arguments about the warrant affidavits validity that Allen has abandoned on appeal. The relevant portions of the Franks memo asserting the argument raised on appeal is found at Appendix 4, which I do not have. Okay, Allen did not preserve this issue for appeal. I'm not a lawyer, right? I'm not a lawyer in my country. I'm certainly not a lawyer in Indiana. So I don't know how valid this argument is, but I'm just reading what is written. Allen's Fourth Amendment challenge to the admission of this evidence suffers from multiple issue preservation problems. First, Allen waived this issue entirely by failing to object to the evidence at trial. So the evidence relating to the search warrant. So that would include the ballistics, that would include anything that was found in the house. His car also, But because we didn't see the trial, we don't know whether these were objected to at the time or not. Now, the trial transcript is available. I guess we could go through and look to see whether there were objections in the trial transcript. First, Alan waived this issue entirely by failing to object, right? Okay. A pre-trial motion to suppress is insufficient to preserve an issue for appeal. Footnote. The recent amendment to Evidence Rule 103B, which is not effective until July the 1st, allowing preservation through pre-trial rulings, was not in effect at the time of Alan's trial, therefore is not applicable. Interesting. So they're working through the minutiae here of the law. To preserve a claim of error, the defendant must contemporaneously, which you can never say, object to the admission of the challenged evidence at trial. Alan did not object when the state elicited testimony pertaining to the search of his house and affirmatively stated he had no objection to the admission of the gun and cartridge and the photographs of the Carhartt jacket and knives. By failing to reassert his Fourth Amendment challenge at trial, and instead stating that he had no objection when the evidence was proffered, Alan has waived appellate review of his challenge to this warrant. Do they have good grounds here? I don't know. So C. Halliburton stating that defendant may not affirmatively state at trial he has no objection to the admission of evidence and then claim such admission to be erroneous on appeal. Alan, who does not acknowledge this waiver, makes no argument that the admission of this evidence constituted fundamental error. He has therefore waived any claim of fundamental error. Moreover, Fourth Amendment issues generally are not subject to fundamental error review because they do not undermine guilt. Fundamental error review is available only when a defendant claims fabrication of evidence or willful malfeasance, of which there was much in the pre-trial stages, but it's proven it by the investigating officers. There is no claim of fabricated evidence here. And Alan's assertion that Detective Liggett recklessly made false statements or material admissions is not a claim of willful malfeasance. Only deliberate lies or intentionally misleading omissions could constitute willful malfeasance. Well, I would have argued that there was willful malfeasance. Again, it's proven it though. Oh God, they've got a dictionary definition of willful. Oh, good God. For both of these reasons, Alan waived Frank's challenge is also not subject to fundamental error review. Second, even if the entire issue was not waived. Oh, thank you, the Tooth Fairy. Thank you so much for the $49.99. Thank you. It's Krista. Thank you. You're so generous. It's hard to listen to these lies. I know. It's horrible. It's the law. It's proving. You whatever you know, the law only listens to what you can prove. Tony Liggett was lying through his teeth, but it's proven it. Okay, so second, even if the entire issue was not waived, the fourth way in which Alan alleges the magistrate was misled, Alan's description of his clothing that day and his wife's confirmation that he owned a blue Carhartt, is raised for the first time on appeal. Allegations of error raised for the first times on appeal are waived. A trial court cannot be found to have erred as to an issue or argument it's never had the opportunity to consider. Okay, so this is relating to recklessness. The only statements or omissions Alan's claim showed more than reckless disregard for the truth. So more than reckless. more than reckless, but didn't use the word malfeasance, are the two statements pertaining to a blue jacket. One of these statements, Alan's description of the clothes he was wearing, is not properly before this court at all and will be argued below. That leaves only Carbo's description of the court available for fundamental error review. Carbo saying that it was a tan coat that she saw the man wearing. Excising that sole statement from the affidavit does not undermine the existence of probable cause and thus the validity of the warrant, much less undermine the fundamental fairness of Alan's trial. A defendant may not object on one ground at trial and then raise a different ground on appeal. Below, the only statements or material admissions identified by Alan were Blair's description of Bridge Guy and a disagreement with the Carbo sketch, Blair's description of the car parked at the CPS building, and Carbo's description of the man she saw walking. Alan did not identify Liggett's recitation of Alan's description of the clothes he was wearing and his wife's confirmation of his ownership of a blue Carhartt are false and misleading. Yeah, but these were the things that were in the probable cause affidavit. So these are the things that he's objecting to. So that makes no sense. These were the things that were in the probable cause affidavit. So Blair's description of the man she saw and the car, and Carbo's description. There was no mention of what Rick Allen. Oh, I think there maybe was mention. I can't remember. But certainly not that Kathy confirmed the ownership of a blue Carhartt. That was not mentioned at all in the probable cause affidavit. So it's perfectly logical that you would mention the things that were in the probable cause affidavit when you're talking about the invalidity of the search warrant. This is nuts. This is nuts. Okay, because Alan's reliance on these statements is an improper appellant attempt to supplement his Franks challenge, this court should limit any consideration of this issue to only the first three ways that Alan contends the affidavit is misleading, as those were the only allegations the trial court had the opportunity to consider. So we want to skip over anything to do with Franks. That's basically what we're saying here. Okay. So C. Daring finding alleged omissions from the affidavit waived because Daring did not raise them at the trial court and limit our discussions to the omissions raised in Daring's memorandum of the trial court in support of his motion to suppress. Finally, to the extent Alan suggests that success on this issue results in suppression of his confession, that claim is doubly waived. First, although Alan challenged the admission of his confession below on other grounds, he did not raise any Fourth Amendment challenge to their admission or object on the basis that they were the fruit of an unlawful search. Well, no, he objected because he was psychotic, and he shouldn't have been admitted because he was psychotic. So again, you're bypassing an issue. A defendant may not object on one ground at trial and then raise a different ground on appeal. Because Alan did not object to the admission of the statements on Fourth Amendment grounds at the trial, he is precluded from challenging their admission on that basis for the first time on appeal. Second, Alan's bare assertion that his statements were suppressible fruit of the search is unsupported by cogent argument. All arguments must be supported by cogent reasoning, and citation to authorities, the failure to make a cogent argument waives a claim for appellant review. Alan's to be suppressible fruit of a search of the house, Alan's confession must constitute evidence derivatively gained as a result of information learnt during the search, rather than through a means sufficiently distinguishable as to be purged of any taint from the search. I suppose they could argue if his house wasn't searched, he would never have been arrested, therefore he would never have been in Westville, and therefore would never have confessed, because he would never have become psychotic. So I get the chain of, dominoes, I guess, but there's more reasons to claim those confessions should not have been heard by the jury at all, because he was psychotic. Alan does not explain how volunteered statements made to family, doctors and correctional staff more than 5 months after the search of his house and after he had been advised of his rights, appointed counsel and a court found probable cause to support his arrest could constitute a fruit of that search. I think it's a tenuous argument. It is a tenuous argument. Okay. It is not this court's province to develop an argument on Alan's behalf. By failing to present cogent arguments on this point, Alan has waived any claim that his confessions are suppressible due to the alleged invalidity of the search warrant. Okay. B. Alan has not shown that probable cause for the search warrant was predicated on false statements or material omissions. Again, it's not what we know. It's not what the attorneys know. It's what they can prove. Waiver notwithstanding, Alan has not established a Franks violation. Well, Judge Gull wouldn't know, because I don't believe she read any of that Frank stuff. I just don't believe she read it. Probable cause exists to issue a warrant when the totality of the circumstances set forth in the affidavit demonstrate a fair probability that evidence of a crime will be found at the location. Well, there was no evidence of the crime found at the location anyway. Search warrants were presumptively valid, and in assessing whether an affidavit established probable cause, doubtful cases should be resolved in favour of upholding the warrant. In favour of the state. A defendant may invalidate a warrant by proving by the preponderance of the evidence that the affidavits used to obtain the warrant contained perjury by the affiant. Well, I think there was. Or a reckless disregard for the truth by him. So they're using the word reckless. Earlier on, it said we're not allowed to use the word reckless. We've got to use the word malfeasance. Now we're being told that a defendant can invalidate a warrant by using the word reckless. Oh, good God. And the rest of the affidavit does not contain material sufficient to constitute probable cause. That's the whole argument. A defendant does not even receive a Franks hearing unless he first makes a substantial preliminary showing, which Judge Gull refused. Without hearing. So there was no preliminary showing because she refused without hearing. Good God. Good God. Oh, dear. Both that the affiant knowingly or intentionally or with reckless disregard for the truth, in quotation marks, made false statements in the affidavit, and that those false statements were necessary to the finding of probable cause. This is so frustrating. So frustrating. So that's just the legal stuff. The burden to prove deliberate falsehoods or reckless disregard for the truth, as opposed to innocent or negligent mistakes, is a high bar. Oh, of course it is. The presence of intentional or reckless inaccuracies alone is insufficient. So you've got to be intentionally reckless, like you don't care, not making an honest mistake, I guess. is insufficient to invalidate the warrant. Probable cause must no longer exist after those inaccuracies are excised from the affidavit. Although it's not practical for police to include every piece of information relating to an investigation in the probable cause affidavit, an affidavit should include all material facts, which include those that cast doubt on the existence of probable cause. Yeah, so we should have had Betsy Blair saw a young guy and she saw a car that didn't look at all like a black Ford Focus. And Sarah Carbo, in her first interview, said that the coat was tan and the man was muddy but not bloody. Those details perhaps should have been in the search warrant affidavit, but they weren't. Maybe also they could have don't know when the testing on the unfired round was done. Maybe they didn't have that testing at the time. But anyway, therefore, a defendant may also challenge a warrant by claiming the affidavit omitted material information, a reverse Frank's claim. To invalidate a warrant based on alleged omissions, the defendant must show that the police omitted facts with the intent to make or in reckless disregard of whether they thereby made the affidavit misleading. Yes. And 2, the inclusion of omitted information renders the affidavit insufficient to establish probable cause. Well, what probable cause would there be if we take out Betsy Blair and we take out Sarah Carbo? Because the other witness, I think there was 2 other witnesses who saw a car parked at the CPS building, did not say that it was a black Ford Focus or indeed any other car that looked like one. Like the guy said a purple PT Cruiser. One said a smart car, neither of which looked like a black Ford Focus. However, we do still have the unspent round, so it would come down to when that testing was actually done. Did they have the testing at the time? No, they wouldn't, I don't think. So maybe the bullet would still be in. Did they? Did they say? I'm going to have to relook at the probable cause affidavit. Did they say in the probable cause affidavit that it... Yeah, they did know. They did know because they told him on the day he was arrested. What am I talking about? On the day he was arrested, they said that the unspent round found between Abby and Libby was matched to his gun. So they'd already done that testing. So it's questionable whether that should be in. Because what we weren't told in that probable cause affidavit is that she was comparing apples with a whole fruit salad, because she couldn't get the same marks on a round that she expelled without firing it. She only got similar marks when she fired some rounds from his gun. And also, we heard at trial that she couldn't exclude other Sig Sauer P226s. So my argument would be that's tenuous. So we've got Brianne and Rayleigh, who saw a guy that the state believes is Richard Allen. Well, okay. They never said that he was a short guy, and that's the first thing you'd think of when you see Richard Allen. So that's also questionable. So I don't know, be the judge. Is there enough there for probable cause? Makes it certainly a whole lot weaker. Franks protects only against omissions that are designed to mislead or that are made in reckless disregard of whether they would mislead the magistrate. Well, I think we've got that. The affidavit did not contain false statements. Liggett's representation that Sarah Carbo reported seeing a muddy and bloody man who was wearing a blue-coloured jacket and blue jeans was not a false statement. much less one made knowingly, intentionally, or with reckless disregard for the truth. Alan's claim of falsity rests on the video of Carbo, June 7th, 2017, when she is only heard describing the man as muddy and not bloody, and that he wore a tan or lighter coloured coat with a dark hoodie or sweater underneath. So she did say those things. Were those things omitted from the probable cause affidavit? Yes. So there was a willful and reckless disregard for the truth because Sarah Carbo, in one interview, made claims that the description of the man was not bloody, nor was he wearing a blue coat. Do you think the magistrate would have found it useful to have those details that Carbo wasn't sure what she actually saw? I think so. I think so. So a tan coloured coat with a dark hoodie or sweater underneath. Well, that's not what Bridge Guy was wearing. He was wearing a blue coat with a lighter coloured something underneath. Carbo was interviewed 3 times, all before the warrant affidavit was prepared, and Alan ignores Carbo's description of the man in her second and third interviews, which show that neither representation was false. Yeah, but she's giving inconsistent statements. So don't you think it would be useful for the magistrate to know that there was inconsistent statements made? So these are willful omissions, like you're cherry picking the details that the witness gives at a later interview whilst ignoring the witness statements that are inconsistent with what you want the magistrate to hear. That's willful disregard for the truth, if ever I heard it. In those interviews, Carbo describes the man as bloody as well as muddy. Alan acknowledged at trial that she described the man as bloody 16 times in her third interview, and he looked like he had slaughtered a pig. She even marked where she saw the blood spatter on a picture of Bridge Guy during an interview. She believes she used the term bloody once in the first interview, but that it could not be heard on the video because she was mumbling. She also explained that at least 1 hour of her second interview with police was not recorded. Yeah, but the cops were good at that, not recording stuff. They were good at that. You've got to admit that. Liggett's representation that Carbo said the man was bloody was not false. Yeah, but it wasn't strictly true either, was it? Like, she'd said it, but she said something else as well. And she claiming that she was mumbling. And also, wouldn't it have been useful for the magistrate to know that Sarah Carbo was driving at 30 miles an hour, but yet got a good look at this guy for at least 30 seconds? So she was able to really study the pattern of the blood on his person. Any magistrate, I think, with any level of common sense would realise that if you were travelling but down a road at 30 miles an hour, you're never going to be able to look at someone who is walking towards you in the opposite direction for 30 seconds. How are you going to train your eyes onto this person and analyse exactly where this blood spatter is whilst you're driving along a road at 30 miles an hour? You got your eyes off the road for 30 seconds staring at this guy. Look, as you didn't cause an accident. So it's nonsense. Do you think the magistrate would have liked to have known that? Yeah, maybe. Some more reckless disregard for the truth. Similarly, in Carbo's second interview, she corrected her previous inaccurate statements that the coat was tan. In that interview, she said that the man wore a blue coat with a brown or tan sweater or hoodie underneath. Yeah, but she studied Bridge Guy. She studied the Bridge Guy photo. So the bridge guy photo's already out. She looks at it and thinks, oh, my statement that I gave to the police doesn't look like this. I'm going to change my statement. How do we know that she didn't change her statement willfully because she wanted her statement to match what bridge guy looked like? Dear God. Carbo also told police that the man in the bridge guy photo was the same man she saw on the road, and bridge guy was wearing a blue coat. Liggett's representation that Carbo said the man was wearing a blue coat was not false. Allen cannot prove falsity by cherry-picking isolated statements and ignoring the totality of what Carbo said. Well, right back at you. Right back at you, Tony Liggett. Because how can he cherry-pick the stuff that he writes in the probable cause affidavit while ignoring the totality of what Carbo said? Right back at you. Nor can Allen meet his high burden to show deliberate or reckless conduct merely by the fact that Liggett's affidavit related the information from Carbo's more recent statements to the police, which she had never repudiated, rather than her first statement. That is particularly true in the context of an investigation this large and spanning so many years. Law enforcement interviewed huge numbers of witnesses, in many cases more than once, and many of those interviews, including specifically the interviews of Carbo, took place years before Liggett was preparing this affidavit. Okay, but still, the data's there, the interviews are there. It doesn't matter how much further in the future it is. The interviews are there. All he needs to do is listen to the interviews, and then he's got his information. That's just stupid. He may not have remembered that 5 years earlier Carbo had once described the court as tan. Well, he should have done his due diligence and gone and listened to her interviews, all of them. Dear God. And that she had not said bloody in the first interview, given her overall certainty that she saw Bridge Guy and he was bloody. Unbelievable. Unbelievable. This is insane. And, as will be shown in subsection 2 below, Carbo's information is not necessary to the existence of probable cause. Therefore, even if the alleged false statements were corrected, as Allen suggests, probable cause would still exist. Okay. Let's take a look. Number 2, Allen also claims the affidavit omitted material information by failing to include details of Blair's description of the car she saw parked at the old CPS building that were inconsistent with Allen's Ford Focus, and details of Blair's description of the man she saw on the bridge that were inconsistent with Allen's appearance. So the man appeared youthful in his 20s or 30s and had poofy hair, and that the car was shaped like a 1965 Comet and was a nondescript dark colour, but not black, white or red. That's what she said. That's what she said. Allen did not show that these omissions were designed to mislead or made with reckless disregard about whether they would mislead, nor did he show that the inclusion of this information would have defeated probable cause. The requisite intent to mislead cannot be established merely by showing the fact of the omission itself. The citation they're using is from this particular case. State versus Allen, 2022. Transcript denied. So just because Judge Gould denied it, we're now using it as a legal citation. But Allen points to nothing beyond the omissions themselves as proof that Liggett was being intentionally or recklessly misleading. Failure to present evidence showing the omission of the defendant's exculpatory statements was a deliberate attempt to mislead, was fatal to his reverse Frank's challenge. Darling, blah, blah, blah. Okay. And other evidence refutes the suggestion this was done to mislead. For example, Liggett included the information that a second witness, Terry Wilson, who saw a car parked there only minutes before Blair, described the car as a purple PT Cruiser or small SUV type vehicle. Purple is not black, and neither is a PT Cruiser nor an SUV look like a Ford Focus. Were Liggett attempting to create an impression that the witness had given descriptions consistent with Alan's Focus, he would not have included those inconsistent details from a second witness. But why not include Blair's statement that this car was not black and this car was angular, like a 65 Comet? You could argue that a PT Cruiser and a small SUV is more likely to be mistaken for a Focus than a Comet, if you look at them. So that's why he's included the purple PT Cruiser and not the Comet. And Betsy Blair saying it definitely wasn't a black car, well, he's not put that in for a reason. Indeed, had Liggett included Blair's description, it would only have emphasised that the probative value of the information was not that the witness had given a reliable description of the car's appearance. Their descriptions, after all, were not consistent with each other either. Rather, the information was probative because both witnesses had seen a single car parked in a suspicious manner. A suspicious manner. So a car was just parked there. So there was cars parked all over the place. There was cars parked at the Mears entrance. Why not picking at any of those? At a time when other evidence established reason to believe it was Alan's car parked there. What other evidence? Oh, a car going by at 1:27 on the Who's Your Harvey store camera that you can't tell. You can't tell what type of car that is. So, similarly, Blair had told police she recognised Bridge Guy as the man she saw primarily based on his clothing, which was a match, not on some characteristics of his physical appearance. So we're now saying that the young Bridge Guy sketch that Betsy Blair said was 10 out of 10 in appearance isn't relevant because, well, that doesn't match Richard Allen, but this guy that she saw was wearing similar clothes to Bridge Guy, therefore it must have been Richard Allen. That's some wonky logic. That is some wonky logic. It's therefore understandable, not suspiciously misleading, that Liggett's affidavit focused on that aspect of her description. How long did it take them to write this? I'm not surprised they needed an extension to make up all of this bullshit. More fundamentally, given the construction of the state's probable cause, neither challenged aspect of Blair's information was material to the existence of probable cause, which explains both why there was no intent to mislead or recklessly misleading effect on its omission, and why its inclusion does not defeat probable cause. The video from Libby's phone established probable cause to believe that Bridge Guy was the murderer. Okay, but the important thing is the murderer Richard Allen? That's what we're dealing with here. Not is Bridge Guy the murderer. We're dealing with a whole different kettle of fish. Was the murderer Richard Allen? However, the probable cause to believe Allen was Bridge Guy did not depend on the accuracy of Blair's description. Well, who's the guy then? Who's the guy that Blair saw? Because Richard Allen is not in his 20s with dark poofy hair. The probable cause affidavit did not create any misleading impression that Blair had identified Allen as the man she saw, or Allen's focus was the car she saw. Okay, so she most likely didn't see Allen. She most likely didn't see Allen's car. So why is her information relevant? Probable cause to believe Allen was Bridge Guy rested on the following facts. Oh, I can't believe this. Bridge Guy encountered Abby and Libby opposite the High Bridge on the High Bridge. On the High Bridge. I've got dirt on my screen. I'm struggling to read some words because there's dirt on my screen. Just a minute. Okay. I've got rid of the dirt. I can read properly now. On the High Bridge at 2:13 p.m. Around or shortly after 1:30 p.m., a group of girls passed a single man on the trail walking towards the High Bridge. Brianne Wilbur identified the picture of Bridge Guy as the man they passed. Anna Spath similarly identified the man as wearing a blue coat, and the girls said the man said nothing to them, although Rayleigh Voorhees said hi to him. Oh, well, that's really suspicious that he didn't speak to them. Therefore, it must be Richard Allen. Okay, well, where's the description of seeing a really short guy? Because no Frank's hearing was held, the state did not have an opportunity to present evidence in response to the motion. Why was no Frank's hearing held? Oh, yeah, because Judge Gull denied it. Where the state cites to the trial record in this discussion, it is consistent with the information contained in the probable cause affidavit and thus is reasonably deemed to be evidence that it was known by the police at the time. Shut up. Okay. All right. Blair was walking on the trail to High Bridge and back between 1:46 and 2:15 p.m. When she reached High Bridge, she saw the man in the Bridge Guy photograph standing on the first platform of the bridge, even though she didn't describe him as looking anything like Richard Allen. Okay. She saw a Bridge Guy. And she passed Abby and Libby walking towards the High Bridge as she was walking back to the trail entrance. None of these witnesses saw any other male on the trail during this time frame who could have been Bridge Guy. Okay. But again, it doesn't confirm that any of them saw Richard Allen. All of them gave descriptions that were inconsistent with Richard Allen. Therefore, you have to conclude, even if these witnesses saw the Bridge Guy that was videoed by Libby, it doesn't prove whatsoever that any of them saw Richard Allen. Richard Allen claims that he'd already left by the time that they got there, all these people. It was Allen himself who provided the reasonable ground for believing he was the man that the witnesses saw, and thus he was Bridge Guy. Allen originally told police he was on the trail between 1:30 and 3:30. As I said yesterday, there's no proof of what time Richard Allen said he was there. There's no proof of what he said in 2017 because Dan Dullard did not record it. We've got the words of this dodgy guy, Dan Dullard, and that's it, that's all. We have no proof of what he said in 2017. He said he passed a group of girls without speaking to them as he walked towards the High Bridge. Yeah, but he gave a different number of girls than were actually there. The Freedom Bridge entrance where Allen entered and the group of girls exited is farther west, so farther away from the High Bridge than the Mears entrance where Blair entered. Thus, although Allen began walking the trail approximately 15 minutes before Blair did, he would have walked past the Mears entrance approximately 10 minutes before Blair entered, and thus would have been only a few minutes ahead of her on the trail if he was there at that time. But with no proof that he was even there at that time. They cannot prove he was there at that time. There's nothing links him to that place, and more importantly, to the crime scene. Do they not see that? Mears' entrance was no more than 3 minutes after Blair entered and minutes before blah, blah, blah. Therefore, Allen's contention that the evidence showed only that he was on the trail within the same 2 hours the girls were abducted is incorrect. The timeline is far more compressed than that. That we've no proof. We've no proof of any of this timeline in relation to Richard Allen being there. So that's nonsense. That's absolute complete nonsense. Okay. So he went out onto the first platform and that he did not see Bridge Guy while he was there. Yet, because he was there beforehand. We've no proof he was there at the same time. Thus, Allen has placed himself on the trail and on the High Bridge platform at the same time the witness saw Bridge Guy there. Moreover, although he could not recall with certainty by the time he was interviewed in 2022, well, it should have been recorded in 2017, and then there would have been no problem, would there? Alan told police he was probably wearing a blue jeans and a blue or black Carhartt jacket that day, which was consistent with the clothing Blair saw the bridge guy was wearing. How many other guys would be wearing a blue or black coat that day? This created a reasonable probability that Alan was bridge guy, and therefore the murderer, regardless of any discrepancies between Blair's description of the man she saw and Alan. Blair's description of the man was not the foundation on which Alan's identifier as bridge guy rested. So why include her information then? And the affidavit did not need to remove all doubt or definitively establish that Alan was the man the witnesses saw and recognised as bridge guy for probable cause to exist. Probable cause is not proof beyond a reasonable doubt. It's not even proof by a preponderance of the evidence. Probable cause requires only a reasonable probability, not a prima facie showing of connection to the crime. That's true. That's why we see some very, very weak probable cause affidavits. Alan placed himself on the trail, passing the girls and on the High Bridge platform at the time Blair saw a man there, and those witnesses identified bridge guy as the man they encountered. That creates a reasonable basis to believe Alan was bridge guy. In this context, it is not particularly significant that Blair thought bridge guy looked younger than Alan's age or had longer hair than Alan. Had Alan not placed himself on the bridge at the time, the only reason why Richard Allen is in prison now is because he came forward on the 16th of February 2017 to say that he was there. That's the only reason why Richard Allen is in prison now. Let that sink in. Had Alan not placed himself on the bridge at the same approximate time that Blair saw bridge guy there, those discrepancies between Blair's description and Alan's appearance might be significant to the existence of probable cause. Then her description of the man would be the sole foundation on which Alan's identification as bridge guy rested. But Alan's statement placing himself on the bridge at the right time, again with no proof of the time, to be the man Blair saw, there by itself creates a solid foundation to reasonably believe he might be bridge guy, regardless of any discrepancies in the description of his age or his hair. After all, Blair only saw the man briefly from 50 feet away. It stands to reason that her perception of his clothing might be more accurate than her perception of his age, a characteristic open to subjective interpretation, or the length of his hair. And again, it was not necessary to eliminate all possible doubt that Alan was the man she saw for probable cause to exist. So it was immaterial if her description purportedly allowed for some doubt. Okay, so we got some legal stuff there. Okay. Similarly, just let me take my hoodie off and boil it. Similarly, it was Alan himself who provided probable cause to believe it was his car parked at the CPS building between 1:30 and 3:30. Again, we don't know that that was the time he was actually there, because he told police he was where he had parked and that no other car. No, he didn't say he parked at the old CPS building. He said he parked at the old Farm Bureau building, which is a completely different building. So, no, he never said he parked at the old CPS building. He said Farm Bureau building. Now, that is in the probable cause affidavit that he said Farm Bureau building. They just assumed he meant the old CPS building. This was corroborated by the Hoosier Harvester video, which shows a car matching Alan's Focus driving towards the CPS building at 1:27. It's so far in the distance, you can't tell what make of car it is. You can't tell. That reasonable probability remains even if every witness who drove past gave an inconsistent description of the car. All right, so we're going to believe the Hoosier Harvester camera from a distance away. All right, and we can't identify. Oh, here we go. Although Alan called it the Old Farm Bureau building, there was no such building in that area, and he showed police on a photograph where the building was located. Okay. So even if he was parked there, we don't know what time he was actually there. Blah, 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 blah. Pertinent question is not whether the information excludes all doubt the car was Alan's. The significance of the information from Blair and Wilson was not that they had identified the car as Alan's, nor did the affidavit misleadingly suggest they had. Rather, the significance was twofold. Between 2:10 and 2:15 p.m., the time when Bridge Guy was encountering Abby and Libby on Higher Bridge, and Alan said he was parked at this location. There was no other car parked there, thereby reducing the likelihood that someone other than Alan was also on the trail at that time, and that too, the car was backed in right next to the building, suggesting an attempt to conceal the car's presence or identity. What? So it's just going to blend into a wall. Consideration of the omitted information does not remove any probable cause. The search warrant was valid, and the evidence was properly admitted. Okay, cool. All right. The court properly admitted Alan's confessions. Oh, this is going to be a laugh a minute. Although Alan did not preserve this issue, the trial court properly admitted confessions Alan made to his family, Dr. Waller, and correctional staff. The confessions were voluntary, not the product of state coercion, and therefore did not violate his due process right after self-incrimination under the 5th and 14th Amendment or Article 1, Section 14 of the Indiana Constitution. Okay, so the fact that he was psychotic at the time, that's completely irrelevant. Completely irrelevant. His other state constitutional claims are meritless. And the trial court properly excluded the IPAS settlement, which was not relevant to the voluntariness inquiry. The issue is unpreserved. Although Alan renewed his pre-trial objections to the confessions before the correctional officers and Dr. Waller testified, he did not request a continuing objection or contemporaneously object to testimony about the confessions. More importantly, he affirmatively stated he had no objection to the documents memorializing his confessions to correctional staff and Dr. Waller, and he objected only on the different basis to recordings his confessions to family. Okay. Again, these are things that happened at trial that we're not privy to. I mean, let's go and look at the trial transcript, see if we can find anything. But he does not argue fundamental error, therefore waiving that claim. This court should find this issue waived. So, voluntary. So you can make voluntary statements about guilt to crimes, you know, like killing all your family, even the grandchildren that don't exist, and starting World War III. You can do that while you're psychotic, and that's all completely ignored. But just because you admit to killing Abby and Libby, which is the reason why you're in this very horrible situation in prison, well, we've got to believe those. Don't believe anything that doesn't match reality, though. Don't do that. Both the federal and the state constitutions prohibit the admission of involuntary confessions. Okay, so presumably when somebody's completely psychotic and void of all understanding of reality whilst they're making those confessions, the state of Indiana believes that that is okay, I'm guessing. A confession is involuntary when a person's free will has been overborne by violence, threats, promises, or other improper influences. And we don't know that any of that wasn't happening. We don't know that people weren't saying to him, if you confess, we'll let you see Kathy. If you confess, we'll let you have a meal. Because how much weight did he lose? You know, were they starving him? Lost a third of his body weight. Were they starving him? We don't know. We don't know how he became injured. We don't know. We don't know what coercive techniques were used to break him. Voluntariness is assessed under the totality of the circumstances. So, psychosis, is that included? Under the federal constitution, the state must prove voluntariness by a preponderance of the evidence, and the ultimate determination of voluntariness is reviewed de novo, although underlying factual determinations are reviewed only for clear error. Under the state constitution, voluntariness must be proven beyond a reasonable doubt. There certainly isn't proof beyond a reasonable doubt that those statements were voluntary. Come on now. There certainly is not proof beyond a reasonable doubt. But the trial court's determination of voluntariness is reviewed as other sufficiency matters. An appellant court will not reweigh the evidence of voluntariness and views the evidence in the light most favourable to the trial court's ruling. All right, so just because Judge Gould said that they were admissible, well, we've got to go with that, basically. So just because Judge Gould said, doesn't matter that Judge Gould was making a lot of really prejudicial rulings. Let's just ignore any of that. If there is substantial probative evidence supporting the court's conclusion that the statement was voluntary, that conclusion will not be set aside. So Judge Gould said it, therefore it's fine. Coercive state actions is a prerequisite to involuntariness under both constitutions. So they've just said above that this has got to be beyond a reasonable doubt, and we cannot be sure that the statements he made in April, May, and June of 2023 were done voluntarily without any coercion. Taking any account of the psychosis out of it, take that out of it just for a second, we don't know what coercive tactics were used to get him to confess. We just don't know. Coercive state action is a necessary predicate of a finding of involuntariness under the federal constitution. Does the federal constitution of the United States not consider psychosis? Do they not? That the things you say when you're in psychosis are not melded in reality, therefore surely they're not voluntary. Do they not? I don't know. I'm not American, so I don't know. The Constitution is not concerned with moral and psychological pressure to confess, emanating from sources other than from official coercion. So seemingly not. Seemingly not. The United States doesn't care that people might confess to random stuff like starting World War III and cheating on your wife with his cigarette and killing his grandchildren that don't exist. Right? All we care about is the fact that he said he killed Abby and Libby. And it doesn't matter whatever else nonsense he's spouting, as long as he said those words, that's okay with them. All right. Wow. This remains true even when a defendant suffers from mental illness. Yeah, but there's mental illness and there's mental illness, right? You know, you could have mental illness. Mental illness is very common, where you are not separated from reality, right? You could be deeply depressed, very, very anxious. You could be suffering from a personality disorder. You could be suffering from all sorts of things and still understand reality. In those circumstances, I agree that statements you make, even if you're mentally ill, should stand as long as you understand that you've done it, you know, in the real world. But in terms of psychotic illnesses, in terms of dissociative states, for example, No, you're not connected to reality. So it's completely inappropriate to say some of the stuff that it should be admissible in a trial for one's life, essentially, because you've got a 130-year sentence, should be admissible when you don't know what's real and what isn't. I have a problem with that, a big problem with that. This remains true even when a defendant suffers from mental illness. The defendant's mental state is not enough to render a confession involuntary in the absence of coercive police activity. That is shocking. That is absolutely freaking shocking. Evidence of the defendant's mental condition that impaired his cognitive or volitional capacity is never by itself sufficient. Look, they knew this. They knew this, didn't they? They knew that if they drove him mad and then got him to confess, we can't prove that there was any coercion. All we see is a deeply unwell man, and they knew that those statements would be admissible. That is shocking. That is really shocking. That is really bad. I am shocked. It takes a lot, and I'm shocked. Dear God. Dear God. All right. Through it, stating the mere fact that a defendant is mentally ill does not render a statement inadmissible. Again, there's mentally ill and then there's mentally ill. What we should be differentiating is normal mental ill health, which is very common. Like one in 5 people will suffer from depression, that will affect their life at some point. Anxiety is very common. Panic disorder is common. Personality disorder is less common. But when you are out of reality, when you are psychotic or dissociated, you do not know what you are saying. You do not know what you are saying, and that should not be admissible in court. Even an actively psychotic or delusional defendant can give a voluntary confession. But remember, this has got to be beyond a reasonable doubt. They said above, this has got to be beyond a reasonable doubt. A defendant's mental condition is relevant to the voluntariness inquiry only insofar as it renders the defendant more susceptible to police coercion. Well, it might render them susceptible to, let's say, gentle persuasion by, I don't know, a psychologist that has gained his trust. How about that? Although Allen asserts coercive state action is not a prerequisite under the Indiana Constitution, he provides no analysis to support this assertion. And the Indiana Supreme Court has never held this. Robbins, cited by Allen, contains only a generic reference to the state's constitution, no separate constitutional analysis, and no suggestion that the definition of a voluntary statement under the state constitution differs from that under federal constitution. No other justice has ever adopted Justice DeBruler's concurring opinion in Linithicum, suggesting that police coercion might not be required under the Indiana Constitution. Neither Robbins nor Justice DeBruler identified the applicable constitutional provision, Section 14, or engaged in any analysis of it, and both cases involve statements made in response to police interrogation, not volunteered statements. Volunteered statements while you're psychotic, while you've been losing a third of your body weight in 4 months, and you've been in solitary confinement, and you're to a point now where you're drinking toilet water and eating your own shit. But all that's fine. It's just completely voluntary. All that's fine. It's shocking to me, this. As a psychologist, this is shocking to me, this. State constitutional questions are resolved by examining the language of the text, the first line of inquiry. the history of its drafting and ramifications, case law, interpreting it, and the purpose and structure of our Constitution. As explained in Section B below, under the Indiana Constitution, the prohibition on the use of involuntary statements in criminal cases rests solely in Article 1, Section 14's protection against self-incrimination. Section 14 protects only against compelled testimony, and it's a right not to be forced to speak. And the compulsion it protects against is state compulsion. So Section 14 protects against compulsion by legal process to give incriminating testimony. Allen identified nothing in history, text, or precedent that suggests Section 14 protects against the compulsion to confess that is independent of any state action, or that it applies to volunteer statements not made in response to police interrogation or state-compelled questioning. Without coercive state action, there can be no compelled testimony under Section 14. Wow. 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 Coercive state action is absent. None of the usual hallmarks of police coercion are present in this case. No, because they know the law. They did this in a snidey but clever way. They know the law. Allen's confessions were entirely volunteer statements. They were not made in response to any law enforcement interrogation. Okay, we've got that. We got that. We understand that. Allen was not subjected to torture. Well, that's questionable. Beatings or physical abuse by law enforcement. He was not threatened with harm or offered any promises in exchange for his confessions. I beg to differ. I believe, it's not what you know or you believe, it's what you prove, that he was offered visits with Cassie and he was promised stuff if he confessed. I think that that's what Dr. Waller was doing to him. There's no proof, though. And he was not held incommunicado and denied requested access to his family or legal counsel until he confessed. I don't believe that. I honestly don't believe that. I really don't believe that. The alleged coercive state action in this case rests solely on the conditions of Allen's confinement in the restricted housing unit. But the conditions of Allen's confinement did not rise to the level of coercive state action, rendering his confessions involuntary. Well, do you want to go, whoever wrote this, do you want to go and spend 13 months in Westville and experience what he experienced? Do you want to do that and then come back and give us your assessment? While the conditions of an individual's confinement prior to confession may bear on the question of whether government conduct was coercive, the mere fact that a defendant was held in disciplinary segregation or solitary confinement prior to making a statement is not sufficient to constitute the prerequisite coercion. Yeah, but let's also just disregard the 30-day rule that somebody who is seriously mentally ill cannot be put in that segregation cell for longer than 30 days. And Richard Allen was seriously mentally ill and he was there for 13 months. By the time he started to confess, he'd been there for 4 months and lost a third of his body weight. Let's just completely ignore that, though. Let's rewrite history and completely ignore that. Let's just ignore that. So we'll skip this legal stuff. Oh, confession made after 30 days in solitary was voluntary, according to United States via this guy. Rejecting claim of involuntary confession based on conditions of solitary confinement. Okay, so we've got federal citations here that back up what they're saying. So United States versus Kendra. Confession made after 30 days in solitary confinement was voluntary. Jesus. Jesus, what is the state of the world? What is the state of the world coming to here? Conditions of confinement rise to the level of psychological coercion or compulsion, rendering statements involuntary only when they are so severe to be intolerable circumstances that constitute outrageous conduct by the authorities. Well, I think that was intolerable, but not according to them. State versus McVeigh, holding that the conditions of state prison isolation cells were not so intolerable as to constitute coercion. Again, let's put Todd Rakita, the Attorney General, in Westville, in solitary, subject him to the exact same conditions that Richard Allen was in for 13 months, and let's see how he is after. Let's do that. Let's do that. Anybody gonna volunteer, do an experiment, and go and be Richard Allen for 13 months? See how you do. Be confessing to all sorts. Dear God. Describing an involuntary confession as one procured by means revolting to the sense of justice. Well, there's nothing judicial about this, I'm telling you. Brooks versus Florida, not even an Indiana case. Holding conditions of confinement rendered confession involuntary when for 2 weeks the defendant had been held naked in a small cell with no window, no bed, or other furnishings. No facilities except a hole in the ground serving as a toilet, fed only 12 ounces of pea and carrot soup and 8 ounces of water per day, and denied all contact with the outside world. Conditions the course deemed a shocking display of barbarism. Well, yeah, that is shocking. That is absolutely shocking. But the fact that Richard Allen was already suffering from depression when he went into Westville and he spent 4 months losing a third of his body weight, we don't know what he was given to eat. We don't know what people were saying to him. We don't know what people physically were doing to him. We don't know what psychological tactics Dr. Waller was using. There's all sorts of stuff that we could talk about, but we can't prove it. We can't prove it. So we got another one here. Confession involuntary when defendant held incommunicado for 11 days in cold, unlighted, windowless cell where he was kept chained to a wall, fed bread and water, not allowed to bathe, and told he would remain there unless he confessed. Good God, when was this? 1966. When was the other one? 1967. Well, these are very old cases. I think our standards have improved somewhat since then. Thankfully. So Allen's reliance on Littlefield is misplaced. The mentally ill pre-trial detainee in that case was held for 2 months in a strip cell with no windows, no interior lights, no bunk, no floor covering, and no toilet except for a hole in a concrete floor. So this was 1981. Was deprived of all clothes and given no bedding, was denied articles of personal hygiene, was given no opportunity for recreation outside his cell during the entire 2 months, and was not permitted to have any reading materials in his cell. Although these conditions are several orders of magnitude worse than Allen's, the 10th Circuit did not hold that these conditions for a pre-trial detainee were per se unconstitutional. Rather, it held all the good God. It held only that they could not be imposed without procedural due process. Oh, it's okay. As long as we're following someone's direction due process, that's all right. We can do all that to somebody. On appeal, Allen has not challenged the safekeeping order or the denials of his motion to vacate it, or otherwise raised any claim of procedural due process denial with respect to his placement in the restricted housing unit. Well, don't you think that all that's implied? Good God. Allen's confinement conditions were not outrageous or barbaric. No, they were like a holiday camp. The way it's described here, it's like a freaking holiday camp. Although small, 8 by 12. His cell was the same size as the other restricted housing cells and was furnished with a mattress in a bed frame, a toilet and a sink. Was the water running at all times? Was there actually, water in these things? I don't know. It had a window to the outside. When Alan complained that the window was scratched, the DOC replaced it. What size was the window? What light did he give? He could dim the light in his cell. It's a holiday camp. And he has never claimed that the temperature in his cell was oppressively hot or cold. It is undisputed that Alan was offered regular, nutritious, sufficient food and drink and was given all prescribed medications. He also had access to commissary. He was provided with laundry service and clean sets of clothes every week. Even when on constant suicide watch, he was provided with a suicide smock to wear. He could shower 3 times a week, except when precluded by suicide watch status. He received 1 hour of recreation 5 days a week in indoor and outdoor exercise areas. He was allowed to have a Bible, other books, and reading material. It's a holiday camp. We all want to go there. And crossword puzzles in his cell, and was offered a television for his cell, but declined the offer. Although Alan sometimes refused meals, he never refused more than 4 in a row because he knew they would classify him as a hunger striker. Alan was never held incommunicado. He was appointed legal counsel and received both in-person visits and private phone conversations with his attorneys. Yeah, while he was shackled and while he was being videotaped by the guards. There's that as well. He received at least 2 in-person visits with his wife. When, though? Was that after he confessed? A privilege afforded no other inmate in restricted housing. He could receive weekly visits from a chaplain upon request. Alan had a tablet in his cell and he could use or make phone calls to family and friends. Yeah, but did he have access to that tablet all the time or only when he made a confession? We don't know that. When he broke his first tablet, he was given a second one free of charge, also a privilege afforded to no other inmate. Alan could listen to music, watch movies, play games, and send written messages on his tablet. Again, we don't know at what times he had access to stuff on his tablet. Was it a reward? Did he get to, watch movies on his tablet as a reward for confessing? We don't know the answers to these things. Alan also received regular medical and mental health care. He was checked regularly by medical staff, including daily checks when on suicide watch. He also received daily checks by Dr. Waller and other mental health professionals, to put ideas in his head, while on constant suicide watch and weekly check-ins otherwise. And he was offered at least 1 out-of-cell session with Dr. Waller every week whilst in a cage. Thus, all of Alan's basic needs were met. Look, you wouldn't treat, if you treated a hamster like this, I'd want to kill you. I'd want to beat your head. All right? But, okay, it's fine. It's fine if you're a pre-trial detainee in Indiana. Thus, all of Alan's basic needs were met. He was given food, clothing, shelter from the elements, access to sunlight, basic hygiene, medical care, mental health care, opportunity for exercise, opportunity for intellectual stimulation, opportunity for spiritual care, contact with loved ones, and contact with his attorneys. These conditions were not so barbaric as to overcome a person's will. Okay, great. Conditions of confinement were not coercive when a defendant could shower and exercise 3 times a week. They weren't so harsh as to be coercive when defendant was fed, permitted to shower and exercise regularly, could make phone calls and could receive visits. Moreover, except for the several ways in which he received more favourable treatment and video-only camera in his cell, Alan's confinement conditions were identical to any inmate in restricted housing. Yeah, but those were convicted inmates. This guy was constitutionally innocent at the time he was being held in these conditions. Does that not make any difference? No? Okay. Under the logic of Alan's argument, no statements made by inmates in restricted housing, such as their jail phone calls or Mirandized interviews, could ever be admissible, but he cites no such authority, and the state is aware of none that supports such a novel proposition. This is because the conditions of restricted housing, while undesirable, are a far cry from what is necessary to create an involuntary confession. Wow. Wow. Alan's confessions were not caused by the alleged coercive conduct. For a confession to be involuntary, the coercive state action must be causally related to the confession. All right, so they've got to be beating you up and telling you to confess right there, right then. So Connolly emphasising the essential link between the coercive state action and the resulting confession. Alan's argument assumes that the conditions of his confinement caused his brief period of psychosis, which, according to Dr. Waller's notes, lasted 3 months, not just 1 month. And his psychosis caused his confessions, but both premises are belied by the record. Moreover, the state did not attempt to deliberately exploit Alan's confinement or mental illness to procure confession. We got to take their word for that. Explaining that a defendant's mental condition is relevant to involuntariness only when the police seek to exploit this weakness through coercive tactics. The confinement conditions did not cause Alan's confessions. The conditions did not become more oppressive before the confessions began, nor did they become more benign before Alan stopped confessing. The state never made any threats or promises regarding these conditions predicated on his cooperation or willingness to confess. We've only got the word for that. Moreover, the confessions were not coextensive with Alan's period of psychosis. Well, coexistive. I can't say that. With Alan's period of psychosis, but they were though. He started confessing in April when his psychosis started. And by the time his psychosis had kind of resolved itself, if you will, by the end of June, July, he'd stopped confessing. But by that time, obviously, they had all they needed. He began confessing before he was psychotic, untrue, and he continued confessing after he was no longer psychotic, also not true. Alan was already confessing in early April when he became psychotic. And it was not until April 13th that Alan became gravely disabled. No, that's not according to Dr. Waller's notes. And April 14th, in his psychosis and manic behaviour became significant, he was involuntarily started on antipsychotic medication. Alan no longer exhibited significant symptoms of psychosis, manic behaviour, or lack of impulsive control, and he never thereafter presented any significant symptoms of psychosis or mania, but he continued confessing. Untrue. By May 2nd and May 3rd, Dr. Waller was writing in her notes throughout May that his psychosis was even worse than it was in April, that he was in a vegetative state. So they are absolutely, completely, and totally lying. They are lying about this. This is open lies. Open lies. On May the 3rd, the same day that he confessed, to seeing the van and that, Dr. Waller added a diagnosis of brief psychotic disorder with marked stressors to his record for his presentation within the last month. This diagnosis applied when a person exhibited one or more symptoms of psychosis, not better explained by another diagnosis, that lasted more than 1 day but less than a month, in reaction to an event that would be marked stressful to anyone. But later on and throughout May, she was also adding other things like that he was in a vegetative state, that his eyes were bulging, that he was just completely and totally gone. But let's just ignore any of that. Let's ignore any of that. So never thereafter presented any significant symptoms of psychosis or mania, but he continued confessing. Alan's most detailed confession to Dr. Waller occurred on April the 5th and May the 3rd, before and after his psychosis. Completely and totally untrue. Hold on a minute. Hold on a minute. Hold your horses a minute. Let me find those notes. Why is it not giving me? Here we go. Hold on a minute. Okay. These are Dr. Waller's notes, or a depiction of Dr. Waller's notes. Okay. So let's have a look in May. All right. So May 3rd. Actually, we'll start here. 4:20, Dr. Waller notes disjointed thoughts still going downhill. So this is 20th of April, and has conversation related to competency to stand trial. 4:23, suicide companions are replaced by DOC guards. Now we're into May. 5:3, tells Dr. Waller, I want to confess. 5:9, first incidence of guards tasing his hands. 5:17, Dr. Waller notes disorganized thinking accelerated. 5:18, Dr. Waller notes vegetative state of depression. 5:22, Dr. Waller notes he's having a psychotic reaction to stress. 5:23, second incidence of guards tasing his hands. Then in June, Dr. Waller notes depression peaked, physiological symptoms presenting, trembling, stuttering, knees buckling, and eyes bulging. And then in July, she notes some signs of restoration. So what part of seriously mentally ill do they not understand that was happening in May and June? They are lying. They are so lying. Moreover, the record provides a reason why Alan began confessing in early April. It has nothing to do with the conditions of confinement or their impact on his mental health. First, Alan experienced a marked stressful event around the beginning of April. He received his legal discovery at the end of March, beginning of April. When was it? What day did he receive his discovery? Because he hadn't got his discovery on April the 4th when his attorneys visited. So when did he get it? And he had a meeting with his attorneys on April 3rd. Oh, so you do know the date. So you were saying it was either April 3rd or April 4th yesterday, but now we know it was April 3rd. Okay. So he hadn't got his discovery by then. His behaviour began to change and worsen immediately after these two events. The discovery materials forced Alan to face the horrifying evidence of what he did to Abby and Libby. Only if he was in a psychological state to be able to read the discovery. We don't know, because he was already psychotic by then. The discovery materials forced Alan to face, I've read that, images and events that he'd been able to ignore and repress for over 5 years, in which his guilt had gone undiscovered. He was also confronted with the realization that the state had sufficient evidence for a jury to convict him, and that he was likely going to spend the rest of his life in prison. And he had to confront the realization that his family would be seeing these graphic images of what he had done. These realizations would be stressful regardless of whether one was already in pretrial detention, conditions of that detention, or one's mental health. Second, after spending time in Bible study, Alan said he found Jesus and accepted God into his heart on March 21st. He became preoccupied with religious matters and increasingly concerned about whether he would be reunited with his family in heaven and whether they would still love him if he had committed these crimes. Acknowledgement and repentance of sin is an important teaching in the Christian faith. A new convert's fresh concern about the status of his soul and the will of his God would lead to a desire to confess his sins, particularly when the conversion happened in close proximity to an inescapable confrontation with the sin through the legal discovery. I'm loving this psychological interpretation here. I'm loving it. But why, if Richard Allen was completely non-psychotic, he was completely in touch with the real world and he'd found God and he wanted to confess to ensure his pathway into heaven, how come he did not say that he wanted to make a formal statement and to be rearranged and to plead guilty? How come that did not happen? How come that did not happen? Because that's your logical way out of this, in terms of your new religion, that you want to be sure that everybody knows you're guilty so that he's got his pathway into heaven. The way to do that is to plead guilty in front of the world. Has to be rearranged and for a new plea. But no, none of that happened. All this was done behind closed doors, all hush hush. Why? You've got to ask that question, why? So this is a cool story, but it doesn't fit the facts. This is at least as plausible, if not more so. It's a cool story. That is the combined effect of his religious conversion and his receipt of discovery with its realities to be faced is caused by his confessions, not the conditions of his confinement or his mental health. In addition, the undermining of any causal connection between the conditions of confinement and the confessions, the record also shows the state did not seek to exploit Allen's mental state to induce a confession. We've only got their word for that. The purpose of his placement was not exploitative. Allen was validly transferred to the DOC as a safekeeper and placed in a restricted housing cell out of concern for his own safety, both from other inmates and from himself. This placement gave him significantly greater access to mental health professionals to help his pre-existing depression and anxiety problems that he would have had in the county jail. The state sought to offset the problems of social isolation, provided Allen with access to mental health professionals and a chaplain, regular exercise, regular contact with family, reading material, movies, music, and an offered television. In addition to Allen's access to legal counsel, Dr. Waller advised him he should not talk about his case with anyone other than his attorneys and assured him that he did not have to talk about the case to receive mental health help from her. We've only got her word that that's what she said. The state made no attempt to interrogate Allen after his mental health began declining. When he became psychotic, the state did not ignore that condition while he continued to confess, but instead promptly initiated antipsychotic medication to restore Allen to his baseline mental health. They did everything they could for him. Viewed as a sufficiency matter, the evidence supporting the trial court's ruling proves voluntariness beyond a reasonable doubt under the Indiana Constitution. Even reviewed de novo, the preponderance of the evidence proves voluntariness under the federal Constitution. Because he was a safekeeper, he was not subject to DOC's policy regarding placement length in restricted housing. There we go. So that's completely contrary to what was said earlier on in this document. Allen's other state constitutional challenges are meritless. The admission of Allen's confession did not violate the due course of law provision in Article 1, Section 12. Criminal defendants do not have any general due process rights under Section 12. The due process of law provision of Section 12 applies only to civil cases. Due process in criminal cases is protected only through the specific rights guaranteed by other provisions of Article 1. Thus, under the state constitution, the use of involuntary confessions is prohibited only through the Section 14 privilege against self-incrimination. Allen has waived his claim under Article 1, Section 15 because he raised it for the first time on appeal. In his motion to suppress and at pre-trial hearings, Allen alleged violations only under Section 12, 13 and 14. So because he didn't mention 15, oh, well, we've got to negate all this. Of the Indiana Constitution, he did not allege a violation under Section 15. At trial, he merely incorporated his arguments from pre-trial hearings. Constitutional claims raised for the first time on appeal are waived. And appellant consideration in the first instance is particularly inappropriate when the constitutional claim is dependent on potentially disputed facts. Wow. Regardless, our Supreme Court has specifically declined to interpret Article 1, Section 15 as prohibiting anything more than physical abuse. So declining to reconsider this interpretation. Okay, blah, blah, blah. Section 15 is not a catch-all provision applicable to every adverse condition accompanying confinement. Allen has not contended either in the trial court or on appeal that he was subjected to physical torture or beatings by correctional staff. We just don't know what happened. And he probably doesn't remember because he was psychotic. Complaints about the conditions of his confinement do not present a viable Section 15 claim. So he erroneously cites Helton versus Miller for the proposition that the Indiana Supreme Court has held that Section 15 applies to solitary confinement. First, the language Allen quotes on page 585 or 583, no, 585, is not part of the opinion of blah, blah, blah. Okay. All right. So, emotional abuse. Okay. Harmless error. No, they did it on purpose. Absolutely, Queen of Ravens. They did it on purpose. It was clever. They knew what they were doing. Very clever. Got to hand it to them. Even if all the confessions were involuntary, their admission into evidence is harmless. How is it? They were played to the jury. How is it harmless? So even if we can say they were involuntary, even if the Court of Appeal says, no, I disagree, these were involuntary, we're now going to argue that the confessions that were put in front of the jury are harmless. So juries will completely ignore confessions. Okay, cool story. The erroneous admission of involuntary confession is subject to the harmless error review. Constitutional errors must be harmless beyond a reasonable doubt, meaning that they did not contribute to the verdict. Oh, so just because we don't know how much weight that the jury put on the confessions, then we're going to say that they were harmless. That included and were harmless because we don't have eyes and ears in the jury deliberation room. That's basically what we're saying here. That we don't know how much, to what extent the confessions contributed to the verdict. You know, because we don't earwig on jury deliberation discussions. Come on, this is insane. This is crazy. The timeline, eyewitness evidence, including Allen's initial statements to so we're gonna rehash all that. All right. So we're gonna skip all this timeline nonsense. We've discussed that ad nauseum, matching clothing, Wilbur and Voorhees, all right, all this bollocks. Betsy Blair, Bridge Guy, 230, all that. So pages and pages and pages. They requested extra words, that they use extra words. All they've done is repeat themselves. Why not just say C sections blah 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 above and just not rewrite pages and pages? This is just cutting and pasting from earlier sections. By 2:32, Libby's phone had stopped working. By 3:11, Libby wasn't answering the phone. Blah blah blah. And then, you know, the muddy and bloody man, his clothes were covered in mud and blood, and it looked like he slaughtered a pig. All right, cool story. Cool story. Other evidence corroborated this conclusion. All right, let's start here. So we've gone a few pages down. More significantly, the unfired Winchester 40 caliber cartridge found by the girls' bodies was forensically matched to having been cycled through Alan's 40 caliber handgun. Alan had an identified unfired cartridge, the only piece of Winchester ammunition found in his house, in a keepsafe box. So what? So what? So anybody who keeps Winchester rounds in their house, well, you could be guilty of this crime if the state of Indiana deems you guilty. Okay, cool story. Alan had no possible innocent explanation for how a cartridge that had been in his gun could have ended up at the murder scene. He couldn't explain it because he wasn't there. He couldn't explain it. He didn't know why they were saying to him that his gun had been there, that he got this unspent round there. He couldn't understand it. So no, of course he couldn't explain it. Of course he couldn't explain it. And are we going to talk about the fact that Melissa Oberg could not get the equivalent marks by expelling a round without firing it? And it was only when she fired several rounds that she did get some marks that look similar. So comparing apples with a fruit salad. Are we going to explain that? No. Okay. All right. Bridge guy had a gun and used it to compel Abby and Libby. We don't even know. We don't even know that Bridge Guy had a gun. I think he probably did. I think you do see a gun like shape in his pocket. But Abby and Libby certainly didn't say that be a gun. They absolutely did not. That is made up. This bullshit here. ISP Trooper had listened to over 700 hours of Alan's phone calls, opined that it was Alan's voice heard on the video saying down the hill. Bullshit. Although Alan had 12 own cell phones in his bedroom closet, he did not happen to have the cell phone that he had in 2017. Although when he met Dan Dullard on February 16th, he handed his phone over. And Dan Dullard wrote down the IM whatever number down. So in February of 2017, just 2-3 days after the murders, he was happy to hand his phone over. Just because he doesn't have it now, in 5 years later, anything could have happened to it. He could have dropped it down a drain, or he could have smashed it. He could have been retraded in. There's all sorts of reasons why you might not have a phone 5 years ago that you had 5 years ago. This is not incriminating whatsoever. If you've broken the phone or dropped the phone down the drain, you're not going to have the phone. You're not going to keep it. What, you're going to keep like the shattered shards of a phone just in case at some point in the future law enforcement want to lay out all your own phones to make sure that you've got every single one that you've ever owned? Come on now. And it doesn't matter whether he's still got the physical phone or not. They had the identifying number. They will be able to identify his phone on a geofence or on cell tower data. So you don't need the physical phone to do that. Alan also displayed consciousness of guilt, lying to the police. Although he originally told police he was on the trail from 1:30 to 3:30. Again, we can't prove that. That's Dan Dullard. That's his word. There's no record of that. There's no recording of that. Testimony of Wilbur and Voorhees proves he was arriving at the trail. No, it doesn't, because we don't know that was Richard Allen. Allen claimed he was at the trail much earlier, from 12 to 1 to 1:30, showing he understood the damning implication of the initial timeline he admitted to. Dear God. The order and settlement agreement from an unrelated lawsuit against the DOC was properly excluded. All right, I'm going to skip that because it's completely irrelevant. I don't even know why we're talking about that. I don't understand why we're talking about that, so I'm going to skip it because I just can't give any comment on it. I don't understand. Okay. All right. So all of it's harmless error. Right. Number 3, the trial court made proper evidentiary rulings. So Judge Gull is now up. This is Judge Gull's finest moment. We're now going to discuss the trial court. The trial court's evidentiary rulings were correct. Of course they were. And did not deprive Alan of his rights to present a defence. Oh, so by firing his attorneys, yeah, okay. Trial judges are better at making evidentiary calls than appellant judges. Therefore, trial courts are given wide deference in this area. Oh, she'll love that. In many cases, a court could admit or exclude evidence, and an appellant court couldn't meddle with that decision on appeal. Evidentiary rulings are reviewed only for a manifest abuse of discretion. An erroneous evidentiary ruling is harmless if, given all of the evidence in the case, the error's probable impact does not undermine confidence in the outcome. Federal constitutional errors must be harmless beyond a reasonable doubt, meaning that they did not contribute to the verdict. Okay. The constitutional rights to present a defence is not absolute. Defendants must comply with well-established rules of evidence to assure both fairness and reliability in the assertion of guilt and innocence. The right to present a defence trumps an evidentiary rule only when the rule is arbitrary or disproportionate to the purpose it is designed to serve. Evidence Rule 403 and hearsay rules do not unconstitutionally limit the right to present a defence. Okay. The trial court properly excluded inadmissible evidence. Gull is just awful. She is. The sketches. Alan has waived this issue. The trial court granted the state's motion in limine to exclude the police sketch drawn from Blair's description of the man. Okay. Waiver notwithstanding, Blair's police sketch was inadmissible. How was it inadmissible? So you get the police sketch artist to say, yes, that is my sketch. So you've validated that as the sketch that the police artist did. Then you get Betsy Blair on the stand to say, yes, that is the sketch that I saw, that I worked with the police sketch artist on. And yes, I said myself, so how can it be hearsay? I said myself that this was a 10 out of 10 match to the appearance of the man I saw on platform 1 around 2 p.m. on February 13th, 2017. Tell me how that's hearsay. I don't understand. I must be missing something massive because I don't understand. It's not like Betsy Blair was giving third-hand, second-hand, third-hand, fourth-hand information. She was the one who said that this sketch is 10 out of 10. So how can that be hearsay? So Alan sought to admit Blair's sketch as substantive evidence that Blair did not see Alan. But the sketch was not relevant for this purpose because, as the trial court noted, and Alan concedes, Blair did not make an eyewitness identification as Alan as the man on the bridge. So you don't say, was this sketch Richard Allen? You say, was this sketch the man you saw? That's what you say. Therefore, that's nonsense. And you let the jury decide. Blair identified Bridge Guy as the man she saw on the platform of the bridge. She did not identify Alan as Bridge Guy. Thank you. None of them identified Richard Allen as Bridge Guy. So this whole argument is moot. It's moot. Alan's identification as Bridge Guy came from Alan. All right, cool story. Further, any slight probative value was substantially outweighed by the danger of unfair prejudice and confusion. We don't want to confuse the jury. We don't want to give them any evidence that might lead them to believe that Bridge Guy wasn't Richard Allen. That's going to prejudice the prosecution case. So let's deny the defense a defense. Let's do that. Because anything the defense might say might confuse the jury. Isn't that the whole purpose of having a trial? Of having a defense? Isn't that the whole purpose of cross-examination? Isn't that the whole purpose of the defense being an opportunity to put on their own witnesses? Isn't that the whole purpose of the whole system? It was undisputed that composite sketches are used as an investigatory tool to generate leads and are not used to identify or exclude a suspect. Blair's sketch was an artistic interpretation of her description, of which she herself said was 10 out of 10 for the man she saw. The danger of unfair prejudice was twofold. One, the jury could misuse the unreliable sketch. Unreliable sketch! She said it was 10 out of 10 as substantive evidence. And two, the jury could misuse the sketch to exclude Allen when Blair had not purported to identify Allen. This is just a complete nut. This is nuts. This is just a complete circular argument. That's the whole point. That's the whole point. She did not see Richard Allen. So her testimony is moot. So let's show the jury, let's give the defense the opportunity to show the jury that she did not see Richard Allen. She saw someone else. And all you need to ask her is this sketch the one that you worked with the sketch artist on in February of 2017? And what did you say about it in relation to the man on the bridge? And she said, well, it's yeah, it looks like him. It's a 10 out of 10. I said it was 10 out of 10. That's it. That's all. That's all you need. All right. Thanks. Bye. Can this witness be excused? Yeah. All right. Bye. There's no hearsay. And that is allowing the defense to actually put on a defense, not hamstring them, not, give them a knife and take them to a gunfight. None of that. None of that. Oh, we don't want to confuse the jury. Dear God, Allen's use of the sketch would have misled and confused the jury. No, it would have given them concrete evidence that Betsy Blair saw someone else. The sketch was also inadmissible hearsay. That's absolute complete nonsense. That's nonsense. 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 And I'm not even reading that. It's nonsense. It's not hearsay. It cannot possibly be hearsay. Allen's new claim that the sketch was impeachment evidence is waived. He did not offer it for the reason to attempt to impeach Blair with it. He couldn't. He couldn't use it to impeach Blair because it wasn't admissible. How could he have used it to impeach Blair? Because it wasn't admissible. So they weren't allowed to talk about it or show it. How is this? How is this justice? Moreover, it would have been cumulative. On cross-examination, Blair testified that she had described the man she saw as a young boyish man in his 20s or 30s of average height with brown poofy hair and no visible facial hair or hat. The jury could compare this description with Bridge Guy and with Allen. Allen makes no persuasive argument that the sketch would have been any more impeaching than Blair's description of the person. Yeah, but when you actually see the young guy's sketch, when you actually see it, it really adds to that description. Allen's argument on appeal that the sketch was admissible because it was not a statement under the hearsay rule and that it was adoptive admission by the Indiana State Police aware because he did not raise those arguments for admission. Whatever. Woo. Okay. Bullshit. Absolute bullshit. All right, Tobin. So this was one of the defense experts that wasn't allowed. Tobin's testimony was inadmissible because it was not relevant to an issue before the jury. Toolmark identification as at least 2 subdisciplines, metallurgy and firearms identification. ISP forensic examiner Melissa Oberg testified that she had used the Association of Firearm and Toolmark Examiners toolmark identification methodology and opined that there were 3 different toolmark areas of significant agreement to show that the cartridge at the scene had been cycled through Allen's Sig Sauer model P226 40 caliber handgun. Are we going to ignore the fact that she could not get a match until she fired several rounds? Did she say she fired 6? I can't remember. And she got similar marks then. You can't compare something that has worked through a different mechanism. And also, she said she couldn't exclude other Sig Sauer P226s from also of being able to produce when expending an unfired round to produce the similar marks. Defense expert Eric Warren also had a forensic firearm examiner. Also a forensic firearms examiner who uses the AFDIC methodology testified that he reviewed Oberg's report, did not agree with her process of comparing a cycle cartridge with a fired cartridge, and found insufficient documentation to support her opinion. That was the battle of the experts. Allen also proffered William Tobin, an expert in metallurgy. Tobin is an open critic of the AFDIC and all firearms identification methodology. He believes the discipline is unreliable and should not be admitted in court. The trial court properly excluded this testimony because it was not relevant to an issue before the jury. Arguable. Tobin's proffered testimony went to the reliability and admissibility of the firearms identification evidence. The trial court, not the jury, determined whether expert scientific testimony is admissible under Evidence Rule 702B because the scientific principles upon which it rests are reliable. Allen never offered Tobin's testimony to exclude the firearms evidence as based on unreliable scientific principles under Rule 702B. Because the trial court found the firearms identification evidence admissible, it was for the jury to determine the credibility of Oberg and Warren to assign weight to the evidence. Tobin's proffered testimony was not relevant to credibility. Tobin is not trained in firearms identification, does not do firearms examinations, and did not examine the evidence. I can see the point here, honestly. Tobin was not qualified to offer testimony against the weight or credibility of the forensic identification evidence. Allen's claim that Tobin's testimony was offered to impeach Oberg's credibility is incorrect. Allen offered Tobin's criticism to discredit the accepted, established methodology under the AFDIC. This criticism has nothing to do with Oberg's work. Well, it kind of does because she's comparing apples with a fruit salad. I think that's the reason why they wanted to call him. I think they wanted to really make it clear that this is it's an inaccurate use of a already problematic system. I think that's the point. This criticism was blah, blah, blah. Moreover, Allen extensively cross-examined Oberg and he offered Warren's expert testimony to counter Oberg's opinion. Both Oberg and Warren acknowledged the criticism and ongoing debate in the firearms identification field by the President's Council on the advancements of science and technology and the National Academy of Sciences. Thus, much of Tobin's proffered testimony criticising firearms identification evidence was presented to the jury. For this reason, and due to the overwhelming evidence of guilt discussed in section 2 below, any error in the exclusion, I couldn't do that. Tobin's testimony was harmless. I incline to believe that I don't think Tobin would have added anything extra. It would have been cumulative, but we don't know because we don't know what Tobin would have said. Audio of Allen's movement videos in DOC. Allen presented 15 videos of his movement within the DOC during April through June 2023. So this is during the period when he was psychotic to show how the environmental conditions affected his mental health, which impacted the credibility of his confessions. The trial court sustained the state's hearsay objection to the audio of Alan's statements. So we're now saying we've got a hearsay problem with watching Richard Allen on a video when Richard Allen is the person that's on trial. Okay. The trial court sustained to the audio of Alan's statements, so the jury saw Alan but did not hear what he said during these movement periods outside of his cell. So, oh yeah, I remember now. So they showed the videos, but they didn't show the videos with audio. Why did they not want the audio played? How suspicious is that? You can't say it's hearsay because it's coming from the mouth of the man who is actually on trial. How? I don't understand. I'm obviously misunderstanding hearsay here because I don't understand how that is hearsay when it's the actual person who is on trial. Why do they not want to have the audio played? Why? That is so suspicious. Only the video, not the audio, was relevant to present his environmental conditions. Why? Because you don't want the jury to hear people shouting at him, telling him to kill himself, telling him to confess, telling him what to say. You don't want any of that to be heard before the jury, do you? Alan's sole argument on appeal is that his statements were not hearsay under Evidence Rule 801 because the statements showed his state of mind. But Alan's statements do not facially pertain to his state of mind. Okay. And Alan's attempt to use them for that purpose shows that he was offering them for their truth. He wanted the jury to accept the substance of his statements as true reflections of the contents of his mind. But we're expected to believe that while psychotic, he was able to give true reflections of the content of his mind, i.e. that he actually committed the murders of Abby and Libby. So therefore the confessions are valid. We're expected to believe that, although we're not allowed to hear what he was saying on the audio in prison because we don't want this to be misconstrued by the jury as true reflections of the content of his mind. That's absolutely meaningless. Meaningless. Did Rick ever do a polygraph? No. The defendant who does not testify during trial cannot introduce exculpatory statements made outside of the court in order to enhance his credibility. Okay, I see where they're going with this. Because the statements are self-serving. Oh, so because he was saying, maybe on some of them he was saying he was innocent, maybe, so they contradict the discussion that the state wants to have about, how many times he confessed. So maybe he constantly claiming that he was innocent. Well, that's untrustworthy. That's exculpatory. That might confuse the jury. Therefore, we can't allow the jury to hear that. The statements are self-serving, generally untrustworthy, and not subject to cross-examination. Alan also makes no argument to show the admissibility of other statements in the videos, although he clearly relies on those statements for the truth as well. Further, well, they could get everybody whose voices appear to get on the stand and say, yeah, that's my voice. That's what I said. I mean, what you're trying to do is force Rick Allen to give testimony. Further, Allen had adequate other means to impeach Dr. Waller's testimony, including cross-examination and his own expert witnesses. But it would not impeach Dr. Waller's testimony about Allen's presentation on a particular day with videos of him on different days, even if audio was presented to the jury, because psychosis is fluid. That's true in itself. The evidence was thus unlikely to have an impeaching effect. Yeah, but it would tell the jury what was actually going on, what was actually being said. It would give them insight. Oh, we can't have that, can we? No. Okay. The jury was able to view Alan's environment conditions and his behaviour in the movement videos from April 5th to June 20th, in light of his expert witness testimony of his psychosis and delirium. Any error in the exclusion of the audio was harmless, as explained. Section B below. Oh, God, I can't wait for Section B below. I can't wait for Section B. Alan's other two phone calls on April 3rd. The state presented one jail phone call by Alan on April 3rd at 5:14 a.m. over Alan's objection that two other phone calls that day, 3:12 a.m. and 8:45 a.m., also had to be admitted under Evidence Rule 106, the doctrine of completeness. The trial court's ruling that each call in full met the doctrine of completeness was correct. Alan cited to no authority showing otherwise. Okay. So failure to make cogent arguments supports by citation to authority waives issue. The doctrine of completeness does not mean that once the state presents one full statement by the defendant is entitled to put in any other statement he made at different times. I don't know what Ella's barking at. Ella! Ella. She has to carry on. She can't just stop. Listen to her. I don't know if you can hear it. No context allowed. Exactly. No context allowed. Ella. No context allowed. She just keeps going. She hasn't learned. Shut up yet. Just ignore her. All right. Where was I? So see Hawkins versus State. Rejecting defendant's Rule 106 argument because the State had presented some entire jail phone calls made by the defendant. She was entitled to present other jail phone calls she had made. Yeah, but why can they not? I don't understand. Why can they not bring other jail phone calls in to their own case? The defense is entitled to bring their own evidence, their own witnesses. All right. Evidence Rule 106 is limited by fairness, and where distinct conversations are involved, fairness does not require that the trial court allow admission of otherwise inadmissible hearsay. Regardless, any error was harmless, as explained in Section B below. They're really bigging up Section B. Rick wasn't a drug dealer. Rick Allen wasn't a drug dealer. No, they're talking about Reese. Completely different person. Talking about Reese Davis, not Rick Allen. Rick Allen wasn't a drug dealer. Okay. Dr. Gracian's testimony that Alan's confessions were false. Dr. Gracian testified to the effects of solitary confinement, the symptoms of delirium, and that he saw Alan exhibit symptoms consistent with delirium and false memories. The trial court sustained the state's objection to Dr. Gracian's testimony that Alan's confessions were false. The trial court ruled 1. The witness could not testify to whether Alan's statements were consistent with the facts of the case because the witness did not know the facts. And 2, that it was for the jury to decide if Alan's confessions were false. I'm inclined to agree with this, honestly. None of the 3 bases Alan argues for admission were offered below, so he has waived these arguments. The only basis offered below was that Dr. Gracian knew the facts because he had reviewed all kinds of stuff. Alan wished to elicit anything more from Dr. Gracian, that his opinion that Alan made false statements, and blah, blah, blah. Okay, it would be so, but this would be an insufficient foundation for an opinion. Further, Evidence Rule 704B provides that witnesses may not testify to opinions concerning intent, guilt, or innocence in a criminal case, the truth or falsity of allegations, whether a witness had testified truthfully, or legal conclusions. If that's the brunt of what Gracian was saying, then I agree with it. But I don't know that that's what he was saying, because I can't believe a word that these guys are saying right now. Alan sought to present testimony from Dr. Gracian, and Alan's statements in his confession were false, which was impermissible under the rules. So expert may testify generally about false confessions, but may not testify as to the truth or falsity of the defendant's confession. Denied. 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 Dr. Grassian testified that Alan's behaviour and statements were consistent with delirium, so that he was not denied an opportunity to present this evidence. Alan's combination of the three alleged errors, all of which centred on the admission of his own statements to claim a systemic violation of due process, is unpersuasive. I'm sick of her now. Ella! 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 Alan fully and completely described the environmental, physical, and mental health conditions leading to his confessions, as well as expert testimony on both the effects of Alan's confinement and his mental health. But neither Alan nor the state could present evidence that Alan's confessions were true or false. This is not an unconstitutional infringement on the right to present a defense. Honestly, I do agree with it. I do agree with this. I do. As discussed in Section B, come on, Section B's got to be really good. Like they're really bigging us up now for a big, massive, like climax at the end. Like it's gonna all be like, oh yeah, they're right all along. Perlmutter's testimony and the murders were ritualistic. The trial court properly excluded Perlmutter's testimony, opining this was ritualistic killing, proffered in support of Alan's theory that this was a ritualistic killing committed by ordinists. Expert opinion testimony is admissible only when it will help the trier of fact. Well, it kind of will, because the FBI Behavioral Analysis Unit believed that the crime scene showed signs of some form of ritualistic murder. All right, so Indiana Evidence Rule 702. Rule 702 is restricted by Evidence Rule 403, which permits the exclusion of evidence that will confuse issues or mislead the jury. Why do they even have trials in Indiana? Because it seems that everything that might mislead the jury, i.e. giving them an opposite viewpoint to that of the state, seems to be excluded. What are you doing, Cassie? What time is it? Well, I've been doing this now. I've been doing this now longer than 2 hours. So Cassie now says it's time to stop. Cassie says I've got to stop. However, we're nearly at the end, so I am going to continue. I'm just going to go down and open the door though, and let them out. So please hold on. Where's my please hold? Please hold. I muted my mic. I'm sorry. I think I was only muted for a few seconds though. Yeah, so I'm back. Third-party motive evidence must establish more than a speculative connection to the crime to be admissible. Exclusion of expert at bench trial was harmless because his proffered testimony was speculative. Perlmutter's opinion that this was a ritualistic killing, an opinion she reached before seeing any evidence in the case, was too speculative to be admissible as third-party motive evidence. It was a motive in search of a suspect, as discussed in subsection 7 below. No evidence connected any ordinance to the murders or placed them at the crime scene. Okay. Yeah, but I'm not even going to open that debate. We've discussed that loads. It was... Ella! Oh, my God. You're driving me mad now. It was a speculative motive. Yeah, but there were signs of something going on there. And Westfall and Holder and all of those people were not properly investigated. There was no history of ritual human sacrifice in Ordinism. It doesn't mean to say that these rotters were not murderers, though, does it? And they're fighting downstairs now. Ellen needs a mute button. She does. They're fighting now. Who's here? Me. Oh, hold on. Somebody's come in the door. That's why they're fighting. All right, just a sec. I'm just going to mute it for a minute. Right, okay, I'm back. Sorry about that. So it was a speculative motive. There is no history of ritual human sacrifice in Ordinism. And according to an ordinist, the sacrifice of children would be contrary to the principles of the religion. Well, that's also speculative because you don't know that the people who committed the murders aren't using Ordinism as a front for their murderous, violent personality. Even Perlmutter acknowledged that apart from this case, she had knowledge of only one other Ordinist ritualistic killing, and that case remained an open investigation with no confirmation of a perpetrator or a motive. Oh, okay. So there's another similar equivalent case where you've got potentially a human sacrificed by Ordinists. Which ones? We don't know. Maybe she actually could not identify any other example of an Ordinist ritualistic killing. Perlmutter also acknowledged, so just because she only knows of one means that this one couldn't possibly have been one. Perlmutter also acknowledged that outdoor killings committed with a knife are not necessarily ritualistic killings. True, but let's think about the context. Excluding alternate motive evidence that it was speculative. And it was a motive based on inaccuracies with respect to the alleged symbolism at the crime scene. There was no F in blood on the tree, that there was a misapprehension caused by the reddish tints in the tree bark. Okay, so we're now saying that the F was reddish tints on the tree bark. Cool. When a chemical was applied that turned the blood white, it was apparent that there was no second horizontal line necessary to form an F. The blood formed only an upside down L. Okay, then. Maybe the F didn't register on the tree. Neither Perlmutter nor Allen have ever contended that an upside down L is a rune or an ordinance symbol. Okay. The blood patterns on the bodies and on the ground are inconsistent with the bodies having been hung upside down, as Odin is typically depicted. Well, it doesn't necessarily mean that they were hung upside down, just because Odin's sometimes depicted like that. The depiction of Odin being hung is maybe a representation of how Abby was positioned. Maybe. The sticks on the bodies were fundamentally ambiguous. Professor Turco found it equally plausible that they were not attempted runes at all and could offer only conjecture as to their meaning if it was assumed Arguendo, I've never even heard that word before, that they were intended to be runes, as the arrangements of the sticks did not in any obvious way spell a word. Well, runes are not spelling words. Runes are symbolic. And you might have somebody who is not very good at writing these runes, somebody who is maybe just kind of playing the part, somebody like Elvis Fields, or somebody who's kind of, I don't know, adapting their own system, or somebody attempting a bind rune, which is the combination of two runes together, which gives it a different symbolic reason. Come on now. As seen in the crime scene photos, the sticks were much less suggestive of runes than in the police sketch he was initially shown. With respect to the sticks on Libby, even Perlmutter said that she only believed they had specific meaning to the offender. She could not identify any rune or symbol they purportedly formed. The FBI's Behavioral Analysis Unit was unable to verify or find support for the theory this was an Odinist killing. Yeah, but they said it looked ritualistic. Just because they didn't have evidence that it was Odinist doesn't dispute the fact that it was potentially ritualistic in some way, shape, or form. Determining that neither the blood on the tree nor the sticks on the bodies clearly depict, capture, or present known aspects of Odinism or its symbology. Particularly in the absence of any evidence placing any Odinists at the crime scene or directly connecting one to the crime, the trial court acted well within its discretion in declining to admit evidence of a speculative alternative motive that would have confused the issues, turning the trial into a sideshow debate over disputed. So we're now wanting to turn the trial into a sideshow debate because the defense wants to offer an alternative perpetrator defense. Nice one. Well done. Well said. Dear God. A sideshow debate over disputed claims of Odinic symbology and distract the jury from the issues before it, namely whether the evidence proved Alan committed these murders. Well, was Alan an Odinist? Did Alan wanna why would Alan put sticks on the girls? Why would there be blood on the tree? What's the deal with dressing Abby and leaving Libby naked? What's with all of that? Let's try to explain some of that. If you want to assume that Richard Allen did this, let's try to explain some of that. Namely, whether the evidence proved Allen committed those murders, of which there is no proof, of which I don't know how the jury found him guilty beyond a reasonable doubt. I think it was the emotional closing argument that Nick McClellan gave, about Abby and Libby solving their own murders and all this nonsense. Like, I think they were unduly affected by emotion. And I don't think there was proof beyond a reasonable doubt. There was no evidence that Richard Allen was ever at that crime scene. There was no evidence of his connection to Abby and Libby in any way, shape, or form. I could not have voted guilty in that jury deliberation room, given the evidence that was presented at the trial. That is especially true because motive is not a basis through which the state purported to identify Allen as the perpetrator. That's fine, we're not talking about motive. Because motive was not a significant factor in the proof of guilt, the probative value of evidence of an alternative motive was correspondingly low and easily outweighed by the dangers of confusing the issues and misleading the jury. We're not talking about motive. We're saying that this is signs of a ritualistic killing, and Richard Allen is not part of any ritualistic cult. Therefore, why would there be ritualistic signs at the crime scene if it was committed by Richard Allen? That's the argument. That's the argument. All right, number 7. Evidence of 2 third-party suspects. The trial court properly excluded Allen's proffered alternate suspect evidence pertaining to Brad Holder and Patrick Westfall. Allen was permitted to present evidence challenging the quality of the police investigation and their long-term suspicion that more than one individual had been involved in the crime. But the court excluded his specific third-party suspect evidence because Allen failed to establish any nexus between these individuals and the crimes. Do I think Rick's confession swayed the jury? Yes. I think there was a contributor. I think that the fact that he confessed, the people who go into the deliberation room and argue that he's guilty can use that. But he confessed. They can keep saying that. To the admissible evidence must be relevant. It must tend to make a fact of consequence more or less probable than it would otherwise be. Evidence which tends to show that someone else, she is driving me insane now. Someone else committed the crimes logically makes it less probable that the defendant committed the crimes and thus meets the definition of relevance in 401. Relevant evidence may be Ella! Enough! Good God. Relevant evidence, she'll start again in a minute. Evidence may be excluded if its probative value is outweighed by unfair prejudice, confusion of issues, or the potential to mislead the jury. Can't mislead the jury. Can't confuse the jury. Right, I'm gonna have to go and see what she's actually barking at. I can't even see what she's barking at. There's somebody been delivering stuff, so maybe it's that. Okay, we can skip through this. The police investigated Holder and Westfall and never found any evidence connected them. Yeah, because they didn't properly investigate them. Right, I want to get to section B. So Holder had the alibi that he was at work. Okay, but that's assuming that that Libby and Abby were dead by 2:32. We don't know that they were dead by 2:32. No one's ever provided any evidence of the time of death. So without Holder, the theorized connection to Westfall necessarily fails. It was a central tenet of Allen's ritualistic killing theory that the crimes were not committed by one person. He never contended below that Westfall committed the crimes by himself. But Westfall could have had other people and Holder come later. Holder's ex-wife's statements that Holder and Westfall murdered Abby or was involved in the murders, statements Holder denied making, were inadmissible hearsay. But, okay, speculative theorising lacking any admissible evidence directly connecting either man to the crimes does not rise to the level of admissible third-party evidence because they weren't properly investigated at the time. We've talked about this so many times on this channel, so many times. All right, this is now the climax. We have been now talking about this, together with yesterday's live stream, over 4 hours. We've now got to the climax of the event. This is the star of the show, Section B. Section B, harmless error. Any of these alleged errors, individually or collectively, is harmless, given the powerful, independent evidence of guilt. The timeline and eyewitness evidence, including Alan's initial statements, we're just going to rehash. We're going to rehash it all again. This is just a copy and paste. Alan admitted to be caught near the Freedom Bridge and began walking trail about. And he didn't admit that. No, he didn't admit that. We don't know that it was his car on the Fusio Harvester camera. He admitted he was wearing a dark jacket. So what? Which matched the clothing worn by a bridge guy. So what? That's irrelevant. Identified himself as the man walking past Wilbur and Voorhees. No, we don't know that it was the same group of girls. We don't know that they saw him and he saw them. They may have seen someone else. They didn't say that they saw a short guy. They said they saw a taller guy. So the description didn't match Richard Allen. Richard Allen said he saw a group of girls, but it was a different number of girls. So we do not know that Allen and the girls saw each other. They saw someone. We don't know. We can't prove that they saw each other. This is absolute bullshit. This is just copy and pasting. This is copy and pasting. They did not need extra words and extra pages for this. They did not need extra words and extra pages. They're just rehashing this for effect. Section B, harmless error. Alan also admitted when he reached the high bridge, he walked out to the first platform and stayed there for a few minutes. But he's not in his 20s with dark, poofy hair. And if he's not there at the same time as Betsy Blair, then it wasn't him. And they've said themselves earlier on in this document that they're not using Blair's testimony to say that she saw Richard Allen. Well, if they're using her testimony for something else, what is it? Because it's Richard Allen whose life is now completely destroyed by these allegations and this conviction. So we're now saying that this is Betsy Blair is not, her testimony is not that she saw Richard Allen. It's that she saw someone on the bridge, and that's it. That's why the sketch was disallowed. Blair entered the trail at the Mears entrance, or just after 1:47, blah, blah. It's just all rehashed. It's just all rehashed. This is meant to be the climax of the show. Well, we're waiting for Section B, thinking that there's some great enlightenment. It's all the same. It's all the same. It's copy and paste. Giving Alan's admissions, placing him on the trail on a high bridge platform. This is nonsense. But I honestly believe that this appeal is going to fail. I think Richard Allen's appeal is going to fail. I mean, appeals so rarely win anyway. But I'd be incredibly surprised. I mean, I'd be elated, but I'd be incredibly surprised if this appeal actually wins. Other evidence corroborated this conclusion. Oh, God, the cartridge, bridge guide, a gun, blah, blah, blah. Allen also displayed consciousness of guilt by lying to the police with no proof that he lied. With no proof of what he said in 2017. Allen confessed to kidding. No. This is in reference to Allen subjected the state's case to adversarial testing by presenting evidence of inconsistencies between eyewitnesses, descriptions of bridge guy, and Allen's. This is terrible. This is terrible. This is all just repeated. Let's read this paragraph. So, moreover, as he's been referenced throughout, Allen subjected the state's case to adversarial testing by presenting evidence of inconsistencies between eyewitness descriptions of Bridge Guy and Allen's appearance and between eyewitness descriptions of the car parked at the CPS building and Allen's focus. Expert testimony challenging the validity of the ballistics match, the length of time Allen was held in restrictive housing, DOC policy on restrictive housing and its effects on mental health, expert and lay testimony regarding Allen's mental health at the time of the confessions, and video evidence of Allen's behaviours around the time of the confessions, and evidence that Libby's phone data showed a headphone connection in the audio output during the evening of the 13th that was not explained by the state's theory of the crimes. If those attacks fail because even one juror to have reasonable doubt, then this court can be confident that none of the comparatively insignificant pieces of excluded evidence complained about here would have made any difference to the verdict. There's that. Omission of a possible explanation of a cell phone. The omission of the Google search was at most harmless. Defence witness Stacey Eldridge opined that between 5:45 and 10:32, Libby's cell phone registered a code in the Knowledge C database of an audio output start, which indicated that headphones or an aux cable was plugged into the phone. As we know, there was water and debris on the phone when it was found. To Eldridge's knowledge, water could not affect the plug-in data. The state's two cell phone experts, Christopher Cecil and Brian Bruner, testified that they did not know what audio output start meant. On cross-examination, the state asked Cecil if he had done a Google search to determine if water damage could cause audio. Yeah, because he did. He did a Google search of like some kind of help forums during the break, and that was allowed. That was okay. Water damage or dirt within the headphone plug-in could cause the phone to register an audio output. Yeah, but how did... I don't think water can, honestly. Dirt definitely can, because I've had this exact problem with an iPhone 6, and the exact same problem. It was fluff in the headphone port, and it was telling me that headphones were plugged in, when obviously they weren't. Once they got the fluff out, it was fine. So I know dirt or something inside the phone can cause the headphone to the phone to assume that there's headphones in there. However, how did the dirt get out again? How did the dirt get out again? Like, how did it get in at 5:45 and how did it pop itself out again at 10:32? Like, this explanation is not explained by that. And if there was water damage, the iPhone has a sensor that detects water damage, so you'll be able to tell if that phone actually was water damaged. So the dirt argument is a valid one, but you've got to explain to me how the dirt got in at 5:45 and then got itself out again at 10:32. Oh, she's off again. We're so nearly there now. This information was proffered an alternate theory of the cause of the audio output code, but neither of the theories made it more or less probable that Allen committed the murders. As argued above, Allen's identity was proven through eyewitness testimony. Oh, not again. All right. The trial court properly denied Allen's motion to correct error. The trial court, so the motion to correct error was after the trial, did not knowingly present false testimony through Weber in violation of Napier versus Illinois. A conviction obtained through the use of evidence that the state knows is false and does not attempt to correct violates a defendant's 14th Amendment due process rights. To make a claim under Napier the defendant must establish that there was false testimony. The government knew or should have known it was false, which they absolutely should have known it was false. We're talking about Brad Webber and what time he arrived home in the van. Allen failed to show that the state presented false testimony through Webber. Allen's argument is predicated on surveillance video. He claims shows Webber's van arriving at 2:44 p.m., but Allen did not present any verification of the date or timestamp on that video. Okay, well, how can you when it's years later? How can you? When it wasn't investigated at the time. There's no way to prove it. But what you can prove is the time that Brad Webber's phone connected for the first time in like many hours to the cell tower. That absolutely can be proven, and that was 2:50. So it matches up with him, driving along the road, being seen on surveillance camera, and then arriving home at 2:50. It matches up. The time matches up. It's common for timestamps on surveillance videos to be inaccurate by minutes or hours. Okay. So we know that the Who's Your Harvester camera was fast. All right. We don't care. Okay. Allen also offered no foundation to support the ping evidence of the FBI report. Without any evidence as to whether or when Webber had his cell phone turned on, the absence of pings earlier does not prove he was not home earlier. Well, oh my God. So we're now disputing the FBI's own ping data. We're now excluding that. Okay. At the very least, what this provides is reasonable doubt, and this should have been part of the evidence presented to the jury and let the jury decide. The fact that this was hidden from the jury, that's the point that they're making. This was hidden from the jury. The jury do not know any of this. It completely negates the state's timeline of events, completely and totally. So present it to the jury and let them decide. So the FBI ping data, well, we absolutely don't know whether Brad Webber had his phone turned off earlier on and he just turned his phone on at 2:50 and it pinged. Okay, present that to the jury and let the jury decide. We don't have any proof that the 2:44 timestamp was accurate. However, there's no reason to believe it wasn't accurate. Let the jury decide. But no, the jury didn't get the opportunity to see it because it was hidden by the state. Allen's claim also fails on the third step. In this step, reviewing courts will consider whether the defendant had an adequate opportunity to expose the false testimony on cross-examination. The state had disclosed the surveillance video from Webber's neighbour and the FBI ping report to the defence prior to trial. Yeah, I do think that this was, I don't know whether it was ignored by the defence or it just wasn't seen by the defence. This was a slip-up. The defence could have presented it, or at least ask Gull, could they have presented it? I do agree that this was a slip-up by the defence. Like, talking about it after is all well and good, but it was there in the discovery. How far away is the location of this case to Tuscan? Where's Tuscan? I don't know where Tuscan is. Somebody else might be able to answer. Despite having the surveillance video at trial, Allen never asked Webber to identify his van on that video or expose his allegedly false testimony. I agree. I do agree with that. The crux of Allen's claim is that Webber's testimony was false. I do believe Webber's testimony was false. Oh, I mean Tucson. A long way. A long way. Like, Tucson, Arizona is right over in the west. This is like right in the middle. A long way. A long, long way. This is just crazy. I agree. I do agree with them. I do agree with them. This is something the defence either slipped up, didn't see it. I don't know why they didn't present this. I suppose, like Brad Webber's testimony, it was taken a little bit on the hoof about it. Maybe they just didn't see this beforehand. The jury had ample evidence to evaluate not only Webber's credibility, but the credibility of Alan's confession. Oh, don't start that again. Don't start that again. Alan was not denied due process. The jury was able to evaluate the witness's testimony in light of inconsistencies and effectively act as a fact finder. Transcript denied. This court should affirm the denial of Alan's motion to correct error. Okay. We're done. Certificate of word count. I verify this brief, including footnotes, contains no more than 24,000 words. You could easily have done it in less than 20. You could have done it in less than 15 if you reduced your level of repetition. It was completely denied due process. I have to agree with some of these points. I do agree with some of these points that the motion to correct error is all well and good after the fact, but to have presented that video and impeached Brad Webber with it and the FBI ping data, I think that would have really given the jury some food for thought. But it is what it is. It is what it is. Anyway, guys, I'm going to go now that Ella's like calmed down because whoever's delivering stuff. Right. Vintage and Collectionables Roadshow. That's what's come through the door. No idea. It's like really glossy paper as well. It's like one of those booklets that feel like really thick when they're not. Somebody's out delivering them. All right. Thank you all for joining me. I know this has been a long one. It's been a necessary evil, though, to read through. And we now await, we absolutely now await the decision of the appeals court. I don't know whether they're going to be offered a hearing or whether they're just going to give a written order. I don't know what happens next. Did they bring up the safekeeping in the appellant brief? I can't remember now. I think they did. I can't remember now either. It's annoying that these things are so now very spaced out. It's like impossible to keep everything in mind. And given how long this is and given how long the appellant brief is, it's impossible to. It could take hours and hours to literally compare them side by side. Yeah, they're given the right to respond. Yeah, they do have the right to respond if they want to. Who decides this at the appeals court? Judges. An appeals judge or judges. I don't know how many judges, but it goes to the judge. When do we expect to hear from the court? Don't know. But the Richard Allen's side will be given the right to respond first. So that will be the next thing. But look, the appellant brief was released in December. So we're now towards the end of March before we've got this response. So if the Richard Allen side want to respond to this, we're going to be looking a few more months. And then it's probably going to be months before we get a decision from the court. Now, again, like I said, I don't know whether they get a hearing or whether it's just a written response that other people might know. They will weigh both arguments, and this is rambling. It's proving the state actors. I just don't think it's going to be successful. They do need to respond. They absolutely need to respond. I'm sure they will. I think they will. I think they'll take their opportunity to respond. Like, they don't have to, but they have that right to, so I think they should. But then does the state get the opportunity to respond to that? I mean, how many different responses are they allowed? I don't know. Honestly, we get so few appeals, you know, to things. Like you get like Sarah Boone and people like that saying, oh yeah, I want to appeal. But to actually see it through to this stage, it doesn't happen very often. Or it happens in cases where nobody's watching. Everything is irrelevant because nobody's watching. And it's just that, you know, this case has been popular. It's always been popular. And now we're seeing it all played out. It's a really elongated. And then I think the appeals process overall, like I say, can take up to 2 years. And then if that fails, then you go into post-conviction relief. So you get the very slim opportunity to be able to find some way that you provide new evidence to get a new trial. What do I think the outcome will be? I think this appeal will fail. I do think this appeal will fail. But I hope I'm wrong. I sincerely hope I'm wrong. Sincerely hope I'm wrong. Right, I'm going to go. I am going to go. I've been on here longer than I thought I was going to be. And most people have left. So, all right. Thank you so much, the Tooth Fairy, for gifting the $49.99. Very generous earlier on. Thanks, as always, to the mods. And I will see you tomorrow. I've got stuff to talk about with Nancy Guthrie. But hey ho, it is what it is. All right, bye guys.